So, Donald Trump has just lost his final appeal at the Supreme Court to stop the release of his financial records. And now he is confronting an ultimatum never before issued to a former U.S. president in American history: comply within 72 hours or face jail time for contempt. And what set off this crisis? His own attorney's choice to submit what the court labeled a baseless emergency request that stalled proceedings for 2 weeks, even as Trump's accountants were already under subpoena. The Chief Justice did not hold back in the rejection, warning that any further efforts to obstruct lawful court directives would bring immediate penalties, including possible incarceration. This is not merely another legal hurdle or procedural defeat. We are witnessing the Supreme Court directly threatening a former president with imprisonment for defying judicial authority. And believe me, the 72-hour countdown that began the instant that ruling was delivered is sending massive shockwaves through Trump's legal team and the entire MAGA sphere. It is honestly surreal to see a moment where the nation's highest court is essentially telling Trump that his stalling tactics have finally failed and that consequences are now inevitable. Let me walk you through how we arrived here. This fight over Trump's financial records has dragged through the courts since 2019, when Manhattan District Attorney Cyrus Vance first subpoenaed 8 years of Trump's tax returns and financial documents as part of a criminal probe into potential bank fraud and tax violations. Trump resisted at every turn. His lawyers invoked executive privilege, claimed presidential immunity, argued political persecution, and filed appeals in every possible court. The dispute reached the Supreme Court in 2020, where the justices ruled against Trump, declaring that presidents are not above the law. But even after that setback, Trump's legal team continued to battle with fresh procedural challenges and delay strategies. According to a Politico report dated November 28, Trump's accounting firm, Mazars USA, became trapped in the middle, legally required to turn over the records, yet under intense pressure from Trump's lawyers to resist. The firm ultimately informed the court that it would immediately comply unless Trump obtained an order preventing them. That is when Trump's attorneys submitted what they described as an emergency request for a stay to the Supreme Court. But this is where everything came to a head. The Supreme Court did not merely deny Trump's request, they dismantled it. According to CBS News coverage from November 29th, Chief Justice John Roberts, writing for the majority, stated that Trump's filing lacked any credible legal foundation, recycled arguments that had already been rejected multiple times, and appeared intended solely to delay adherence to lawful court orders. The court emphasized that Trump had already exhausted every legitimate path of appeal and that continued obstruction would not be permitted. Then came the decisive blow. The justices issued an order instructing Trump and his representatives to immediately halt all attempts to block the production of the subpoenaed materials, warning that failure to comply within 72 hours would trigger contempt proceedings, including possible incarceration. That is not routine legal phrasing. That is the court making clear they are finished tolerating delays. And before moving forward, let's pause for perspective. The Supreme Court threatening imprisonment for noncompliance is extraordinarily uncommon. It signals that every other option has failed. It shows the court views the resistance as so extreme that only the prospect of jail can ensure cooperation. When the nation's highest court takes such action against anyone, let alone a former president, it marks truly uncharted territory. Here is where it becomes even more compelling. According to reporting from CNN, Politico, and the New York Times, journalists who examined the full order noted that the 72-hour deadline was deliberately set to expire before the weekend, preventing Trump from exploiting holidays or court closures to buy more time. The ruling specifically required Mazars USA to deliver all subpoenaed documents to the Manhattan District Attorney's Office by 5 p.m. Eastern on December 1st, and warned that any interference by Trump or his team would result in immediate contempt sanctions. The court went further, authorizing federal marshals to ensure compliance if necessary. That phrase, if necessary, carries serious weight. It means that if Trump's team attempts any last-minute maneuvers, federal law enforcement already has approval to step in. The shockwave intensified when legal experts began explaining the true implications. According to sources speaking with MSNBC, the Supreme Court effectively eliminated every possible escape route Trump might try. He cannot file another appeal because the court declared the order final and not subject to further review. He cannot argue for more preparation time because he has had over 4 years. He cannot challenge the validity of the subpoena because multiple courts, including the Supreme Court, have already upheld it. He is boxed in, facing a ticking clock that leads only to compliance or jail. This ruling stunned the legal world because it represents the total collapse of Trump's long-standing strategy of delay, and more delay until opposition collapses. That tactic worked for decades in civil disputes. It worked during his presidency when he could invoke executive protections. But it is failing dramatically now that he is confronting criminal investigation without the shield of office. The Supreme Court is essentially declaring that the clock has run out and that further stalling will not be tolerated. Now, this is far from the first time Trump has attempted to shield his finances from investigators. His entire business career has relied on secrecy and aggressive resistance to subpoenas. Consider how he fought the House Ways and Means Committee's request for his tax returns throughout his presidency. Congress holds explicit legal authority to review tax returns for legitimate legislative purposes, yet Trump sued to block them, claiming harassment and political bias. That battle reached the Supreme Court multiple times. Each defeat led to a new procedural maneuver. It took 4 years and repeated losses before the records were finally released in December 2022. And they revealed exactly what Trump hoped to conceal: substantial losses, questionable deductions, and potential tax avoidance schemes. Then came his clash with the New York Attorney General's civil investigation into the Trump Organization's business practices. Attorney General Letitia James subpoenaed documents and testimony from Trump and his children. His lawyers fought relentlessly, invoking the Fifth Amendment, citing attorney-client privilege, and alleging political motives. They repeatedly lost, but each ruling bought more time. When the civil trial finally concluded in 2023, the judge found Trump liable for widespread fraud, confirming that years of delays were designed to conceal wrongdoing. And do not forget Trump's prolonged effort to keep his tax returns hidden during the 2016 campaign and his presidency. Every modern presidential candidate since Nixon voluntarily released their returns. Trump refused, citing an audit, despite IRS confirmation that audits do not bar disclosure. He fought subpoenas, state laws, and public pressure for years. When the returns were finally made public, they showed he paid just $750 in federal income taxes in both 2016 and 2017, paid nothing in several other years, and claimed more than $70 million in questionable refunds. The pattern is unmistakable. Trump resists transparency at all costs because his financial records expose realities he desperately wants concealed. Now, it appears the Supreme Court has decided that Trump's endless litigation to avoid accountability has reached its breaking point. This 72-hour ultimatum is not only about specific documents. It is about whether the legal system can compel obedience from someone who has made defiance a defining feature of his conduct. So, what exactly did the Supreme Court say that makes this so devastating for Trump? Let's examine it. Legal analysts reviewing the full order pointed out several critical conclusions. First, they said Trump's emergency application presented no new legal arguments and merely repeated claims already rejected by lower courts and the Supreme Court itself. The justices described this as an abuse of judicial process. That matters because future courts can now cite this ruling to dismiss Trump's stalling efforts in other cases. He is officially on record as filing frivolous appeals solely to gain time, and here is the key point. The court went further, stating that Trump's pattern of obstruction had escalated to a level that threatened the integrity of the justice system itself. They wrote that allowing any individual, regardless of former office or political influence, to indefinitely delay compliance with lawful subpoenas would erode public faith in equal justice under the law. This was not just a denial, it was the Supreme Court drawing a firm boundary. The order then outlined the consequences in unusually direct terms. CNN legal analyst Jeffrey Toobin observed that the language regarding contempt and potential incarceration was remarkably blunt for a Supreme Court ruling. Typically, courts use restrained technical phrasing. This order sounded like a final warning: comply now or face immediate penalties with no further appeals or delays. The legal mechanism invoked is what heightens the seriousness. Contempt of court can be civil or criminal. Civil contempt aims to force compliance, often through escalating fines. Criminal contempt seeks to punish defiance and can result in jail time regardless of eventual cooperation. The court explicitly referenced both, meaning Trump could face fines and imprisonment at the same time. Former federal prosecutor Andrew Weissman explained on MSNBC on November 29th that the court structured the order specifically to prevent Trump from simply paying fines and continuing to resist. By including immediate incarceration as a possibility, they ensured a consequence he cannot buy his way out of. This was a deliberate step to compel obedience from someone who historically treats legal penalties as business costs. This places Trump's legal team in perhaps the most difficult position they have ever faced. On one side, they must advise their client that the Supreme Court's order is final, and defiance will bring criminal contempt charges that could land him in jail. That advice is straightforward: comply or face incarceration. On the other side, Trump's entire persona is built on never backing down, never conceding defeat, and always fighting. Telling him to surrender documents he has shielded for years contradicts everything he has told his supporters about being the victim of a witch hunt. How do they persuade him that this time is different when they manage to evade every previous order? The reality is there is no escape this time. The Supreme Court has sealed every exit. Trump's lawyers are now trapped. They can advise him to comply, hand over the records, and accept defeat, effectively admitting years of legal battles were futile and exposing him to potential criminal charges that could dominate his campaign. Or they can advise defiance, daring the court to jail a former president, risking criminal contempt, incarceration, and a constitutional crisis. Neither option is favorable. One means surrender, the other jail. Those are the only choices left. This situation is triggering widespread panic within Trump's inner circle and the broader MAGA movement. Compliance would make him appear weak, undermining the fighter image his supporters cherish. According to Fox News coverage on November 29th, allies were already framing possible compliance as a strategic move rather than capitulation. But that narrative is difficult to sell after 4 years of resistance. Meanwhile, defying the court and facing jail would spark an unprecedented crisis. No former president has ever been incarcerated for contempt. Images of Trump in custody could either energize supporters who view him as persecuted or convince undecided voters that he believes he is above the law. Experts remain divided on which outcome would be more damaging politically. The intensity escalated further when Trump responded on Truth Social shortly after the ruling. Reports say he claimed the Supreme Court had been compromised by deep state forces and vowed never to surrender to a corrupt judicial system. He urged supporters to rally and insisted nothing would break his resolve. Legal analysts immediately pointed out that such statements could be used as evidence of intentional contempt if he refuses to comply. Publicly declaring defiance removes any claim of misunderstanding, that is, documented intent to violate a court order. Scholars of constitutional law told CNN that a Supreme Court ultimatum of this nature is virtually without precedent. While courts have held powerful figures in contempt before, issuing a 72-hour comply or jail order to a former president has no historical comparison. Even during Watergate, Nixon complied with the Supreme Court's demand to release tapes, recognizing that defiance would be disastrous. Norman Eisen, former ethics counsel to President Obama, said the order shows the rule of law working as intended, reinforcing that no citizen is immune from judicial authority. Former prosecutor Preet Bharara added that Trump's options have now been reduced to compliance or contempt, with no third path through further litigation. Joyce Vance explained that the Manhattan DA's office has prepared for this moment for months, with investigators and forensic accountants ready to analyze the records the moment they arrive, accelerating the path toward possible indictments. So let's examine the broader implications. If Trump complies, prosecutors gain access to 8 years of detailed financial records. Experts say these documents could reveal how valuations differed across lenders, insurers, and tax authorities, exposing potential fraud. Discrepancies could confirm allegations that Trump inflated assets to secure loans and deflated them to reduce taxes. Now consider the wider legal impact. This firm stance by the Supreme Court may embolden prosecutors nationwide to push harder when Trump employs delay tactics. The era of successfully running out the clock may be ending. Politically, this moment will define Trump's campaign. Compliance risks alienating his base, while defiance risks repelling moderates. The records themselves may reveal damaging details once examined. Institutionally, this moment tests the authority of the Supreme Court. If Trump complies, it reinforces equal justice. If he defies and is jailed, the nation enters unprecedented constitutional territory. So here is the reality. Donald Trump has lost his final Supreme Court appeal, been given 72 hours to comply, and now faces jail for contempt. He cannot appeal further. He cannot delay. He has two choices: surrender the documents or become the first former president jailed for contempt. This is not just about financial records. It is about whether the rule of law applies equally to all. If Trump complies, we may see evidence of decades of fraud and misrepresentation. If he defies, we will see whether the legal system can jail a former president. Either way, the next 72 hours will define whether accountability truly applies to those who have long evaded it. The clock is ticking. His lawyers are scrambling. Prosecutors are preparing. Federal marshals are on alert. And the nation is watching to see whether Trump will submit to the Supreme Court or challenge its authority. The stakes have never been higher, the deadline never more final, and the consequences never more uncertain for American democracy, American government. But now, that is eroding. As European investors reevaluate their positions, the repercussions are felt worldwide. The sell-off in American markets is not just a blip, it signals a profound shift in investor sentiment. When large-scale investors decide to pull back from American assets, it creates a ripple effect, shaking confidence and leading to volatility across global financial markets. This is about more than just numbers. It's about perceptions of stability and trust in the American economic system. Moreover, this situation illustrates the delicate balance of international relations and economic diplomacy. The threats made by the U.S. president have not only alienated key allies, but have also raised serious questions about the reliability of the U.S. as a partner in global finance. If the very foundation of investor confidence is shaken, the long-term implications could be severe, affecting everything from interest rates to global trade dynamics. In essence, what we are witnessing is a critical moment in economic history, where actions taken by a single leader can lead to widespread consequences. The unfolding events challenge the long-held belief that the U.S. dollar is an unassailable safe haven. As the world watches, the stakes couldn't be higher, and the outcomes are still uncertain. It's a reminder that in the realm of economics, trust and stability are paramount.